Hello, everybody. Thank you very much for coming to Crises of Conscience, a discussion on the role of conscientious objection within the medical sphere that we have today. First of all, I'd like to thank our co-sponsors, the Human Flourishing Program at the Harvard University Institute for Quantitative Social Science, the Abigail Adams Institute, the Hippocratic Forum, and the Harvard Catholic Forum. And first, just a little introduction of who I am. My name is Todd Jones. I'm a resident psychiatrist at Brigham. And I've been interested in this concept of conscientious objection for a long time. Can't talk today. Conscientious objection. But that interest crystallized in 2021 when I was participating in the FASPE, which is a non-profit fellowship. It's called the Fellowships at Auschwitz for the Studies of Professional Ethics. And it's a fellowship focused on reviving professional ethics in America. And as participants in the medical branch, we discussed how physicians basically led the way in the implementation of Nazi policies within Germany in the 1930s and 40s. A doctor was in fact 7 times more likely to be a member of the party than an average German employed male was. And among all the medical horrors committed, euthanasia of invalids was key, maybe the key step that really began this process. So afterwards, the Nuremberg Code, the Helsinki Declaration, and the Belmont Report, all of these were codes developing these principles of ethics, what it means to have a role as an objector within war, but then also in terms of research ethics. These pretty much mandated conscientious objection, especially the Nuremberg Code, against unethical orders from a superior. And from these and other fora have also come the 4 key principles that all medical students across the country are taught when it comes to what it means to have medical ethics. And those principles are autonomy, justice, beneficence, and non-maleficence. So that all stemmed from the horrors of the Nazi regime. But 80 years later, we have a very different picture in which people who object to what they see as immoral procedures or services are rather being accused of violating medical duties by appeals to those very principles. Often all 4, but usually some combination of justice, beneficence, and autonomy. So that's sort of the situation we're in. That was 2017. Now this is 2023. And, I'm very sorry. Been in the wrong place. Just wanted to introduce as some senses of the degree to which this has changed has been in April 2017. The New England Journal of Medicine published a sounding board article by Ronit Stahl and Ezekiel Emanuel titled "Physicians Not Conscripts, Conscientious Objection in Healthcare." And this compares the medical profession's conscientious objection clause to the historical refusal to participate in military conscription. This concluded in this comparison that professional societies should declare conscientious objection unethical. And again, also in 2017, the European Journal of Obstetrics and Gynecology and Reproductive Biology argued that objection in healthcare should not be considered a right, but an unethical refusal to treat, and that objection represents an abandonment of the professional obligation that a physician has to patients. And so, with all this background, things have changed nowadays in the year 2023, because ever since Dobbs versus Whole Women's Health in 2022, a different kind of objection has been claimed, in which individual doctors and even whole healthcare systems have been bound to do everything they can to continue performing abortions in states that have restricted it. So, with all this as a background, how do we make sense of an idea of a rigorous idea of objection in which laws and practices are so often seen as worthy of celebration by one side of the political sphere and then burdensome and onerous by the other? Here, the doctor must see to the philosophers. So you are in very good hands. The way that this discussion is going to go is first, We will have a 30-minute, approximately, introduction by Xavier Symons in defense of conscientious objection in healthcare, to be followed by a rebuttal of sorts, a response more properly, by Marcus Corbin. I will start with introducing Dr. Symons. He's a postdoctoral research fellow at the Human Flourishing Program at Harvard. He previously worked as a bioethicist at the Australian Catholic University and the University of Notre Dame, Australia. His research interests include ethical issues at the beginning and end of life, conscientious objection, the ethics of healthcare resource allocation, and pandemic ethics. His first book, Why Conscience Matters, A Defense of Conscientious Objection in Healthcare, was published in July 2022 by Routledge. Dr. Symons received the 2020 Fulbright Future Postdoctoral Scholarship and was a scholar in residence at Georgetown University's Kennedy's Institute for Ethics from September 2021 to March 2022. He holds degrees from the University of Sydney, the University of Oxford, and the Australian Catholic University. And give a warm welcome, if you will, to Dr. Symons.
Thanks very much, Todd, and thanks very much everyone for coming out this evening. And I'd also just like to give a particular mention to Danilo Petranovic and the Abigail Adams Institute for all the hard work they've put into organising this event. I'm immensely grateful, as well as to the other co-sponsors. So on to my remarks. So in recent years, the practice of conscientious objection in healthcare has come under extensive scrutiny. A dominant view has emerged in bioethics scholarship that conscientious objection in healthcare ought to be restricted. Some say it should be banned. But one senses in these discussions a failure to grapple with the full significance of the moral agent's appeal to conscience. Indeed, moral philosophy in general has failed to give adequate attention to the topic of conscience in recent decades. Critics of conscientious objection also rely, I will suggest, on a superficial understanding of the goals of medicine and the proper place of reasoned disagreement within a well-functioning medical system. In this talk, I'll offer a defense of conscientious objection. I'm going to explore the importance of respect for moral agency in medical practice. Clinical disagreement is ubiquitous in medicine, and an ethically mature healthcare system will allow physicians significant discretionary space to act in accord with their considered judgments. It's also instructive to think more deeply about the precise nature of appeals to conscience in social and professional life. I'll argue that an appeal to conscience primarily refers to the consequences for personal integrity and self-coherence of engaging in an action that one deems to be morally wrong. I'll also argue that appeals to conscience are in fact expressions of moral distress. Failure to take these appeals seriously has consequences not just for individual healthcare practitioners, but for the healthcare system generally. And indeed, the marginalisation of conscience in medicine could trigger or exacerbate, quite profoundly, moral distress and moral injury among healthcare practitioners, a problem that healthcare systems are already struggling with, and also jeopardise the cultivation of moral and intellectual virtue. So just to give you a brief overview of this evening's presentation, I'll begin with an overview of conscientious objection in medicine and a discussion of recent criticisms of conscientious objection. I'll also seek to define the topic as a disagreement between a healthcare practitioner on the one hand and a patient or institution on the other about how to realise human goods. Alternatively, conscientious objection can take the form of a healthcare institution that will not participate in the provision of services that conflict with their mission and values. I'll seek to explore the link between conscience and the cultivation of virtue and professional identity, and I'll conclude with some recommendations about the regulation of conscientious objection in medical practice. I think it's worth clarifying that while issues like abortion and euthanasia and so forth, these kind of neuralgic social issues are relevant to this discussion, we ought not reduce conscientious objection to a debate about these matters. Conscientious objection is a second-order practical ethical problem that requires independent analysis of the first-order issues on which it supervenes. So conscientious objection, furthermore, has been reified in a manner that artificially separates it from the spectrum of moral disagreement that one invariably finds in medical practice. I'll try to present a more unified picture of the place of conscience in professional life, and we'll point out the inconsistency of those who want better ethics for medicine on the one hand, but who seek to restrict the exercise of conscience on the other. So just to a brief overview of this topic that is the focus of our discussion this evening. And of course, if you would like to know more about this or any other presentation, you can purchase this lender volume from Rutledge for the eye-watering price of $120. But no, there's fortunately an ebook available, which is much more affordable. And if you're a very good friend and ask me nicely, I may consider sending you a PDF. But on to an overview of conscientious objection medicine. The term freedom of conscience may bring to mind religious minorities persecuted by totalitarian states or imprisonment of political dissidents. But freedom of conscience is a principle that's under strain in even the most ostensibly tolerant liberal democracies. The fractured character of life in pluralist societies means that one is often left fearing sanction when one expresses one's personal views in professional and public life. This tension is particularly acute in medical practice. Doctors are, as a rule, expected to provide medical care to patients in accord with the patient's treatment preferences. A patient's welfare and rights ought to be a central concern for clinicians, as Stalin Emanuel pointed out in the article mentioned by Todd in his introduction. Things get complicated, however, when a doctor is asked to provide a procedure which conflicts with their deeply held moral and religious commitments. Law and professional guidelines typically seek to give some latitude to healthcare professionals to act in accord with conscience, but these protections are rarely absolute. Nor should they be. Conscience has rights because it has duties, as Newman wrote in his letter to the Duke of Norfolk. And a doctor's conscientious judgments ought to, as a minimum, bear some sense of orientation to the good of one's patients. So conscientious objectors, as I'm conceiving of them, do not act based on a distaste for some aspect of their professional work. A conscientious objector is not just like a slacker or a free rider or something like that. Nor is conscientious objection a cowardly dereliction of duty as per the anti-conscientious objection invective of the Great Wars. Rather, conscientious objectors in healthcare, as a rule, act based on a dissenting view of medicine and the morality of certain procedures or services provided by the medical profession. Historically, conscientious objection has often taken the form of civil disobedience to unjust laws and activities of the state. We might, for example, think that the members of the Society of Friends or Quakers who refused to fight in the War of Independence. Alternatively, we might think of widespread resistance and conscription during the Vietnam War. My own father would have been a conscientious objector if he didn't already fail to meet the health requirements for the draft in Australia. And it's interesting to note that conscientious objection has in fact been valorised in popular culture in recent years, particularly because of its association with resistance to tyranny, and partly because of the outstanding moral virtue exhibited by some conscientious objectors. The conscientious objection need not involve disobedience to existing laws or political protest. On the contrary, conscientious objection in medicine is often permitted by law and sanctioned by relevant professional associations. US federal law, for example, protects the healthcare providers' conscience rights and prohibits healthcare facilities from discriminating against individual practitioners who refuse to participate in certain services based on moral or religious beliefs. The so-called church amendments, conscience-based statutes enacted at various times throughout the 1970s, state that public funding for healthcare facilities should not be conditional on the provision of abortions or voluntary sterilisations, and nor can these facilities discriminate against individuals who have a conscientious objection to these procedures. Similar protections are found in the Public Health Service Act, the Coates Snow Amendment, and the Walden Amendment. We can talk more about those in question time if you're a legal enthusiast. Medical associations provide in principle support for conscientious objectors, but also stress the need that patients receive timely access to healthcare services. The American Medical Association's Code of Ethical Standards states that respect for conscience is important for preserving the integrity of the medical profession as well as the integrity of the individual physician, and that in fact physicians should have considerable latitude to practice in accord with well-considered, deeply held beliefs that are central to their self-identities. Similarly, the British Medical Association recognises a limited right to conscientious objection. The organisation believes that doctors should have a right to conscientiously object to participation in abortion, fertility treatment, and the withdrawal of life-sustaining treatment where there is another doctor willing to take over the patient's care. But conscientious objection is nevertheless a live issue in health law and practice, and there has, for example, been a varied approach to enforcing conscience protections by the Department of Health and Human Services in the last decade. As I'll highlight in a second, the Office for Civil Rights at the Department of Health and Human Services is charged with enforcing US federal law on conscience in healthcare. So nurses at the University of Vermont Medical Center recently lodged a complaint with the Health and Human Services Office for Civil Rights after being pressured into assisting with an abortion, and the nurse made it clear to her employer that she would not take part in this particular procedure in general, and she made those representations well in advance of when she was subsequently scheduled to help with an elective abortion. The nurse's supervisor allegedly wouldn't allow her to step out of the procedure and fearing retaliation or that she would lose her job. The nurse assisted the doctor. So the response from the Office for Civil Rights reflected the politicised character of the very Department of Health and Human Services. In August 2019, the office said that the medical centre broke the law in obliging this particular nurse to assist with the procedure. And then astoundingly, officials appointed to the office in 2021 by the Biden administration quietly reversed this decision and dismissed the case before any corrective action or settlement has taken place. So they rescinded the ruling that the University of Vermont Medical Center had violated this particular nurse's right to conscientious objection. So, I mean, I don't want to say too much about the merits of either position. I don't actually know more than the office has actually released to the public about this particular case. However, I think regardless of your interpretation of this, it would be fair to say that the guarantor of conscience rights may not necessarily be the strict law or professional associations, but the particular interpretation given to those laws by the relevant government agency, in this case, the Office of Civil Rights. But protections for conscientious objectors in the US is arguably much more robust than other jurisdictions. So consider, for example, the situation of physicians in Canada with respect to euthanasia or medical aid in dying, MAID as it's called. MAID was legalised in Canada approximately 7 years ago when the Supreme Court declared that a right to die is implied in the Canadian Charter of Rights and Freedoms. The province of Ontario requires that conscientiously objecting doctors provide their patients with a referral for euthanasia assessment if in fact they don't want to provide that service themselves. A policy directive on medical assistance in dying issued in 2016 by the college stated that objecting physicians in the province are obliged to refer their patients and that they must provide an effective referral or referral made in good faith to a non-objecting, available and accessible alternative healthcare provider. A group of physicians in Ontario objected to this and actually sued or took legal action against the college. And though the courts found that the referral requirement was a burden on physicians, they said it was a proportionate measure given a patient's right to access MAID, given the right to die that had been recognised by the Supreme Court in Canada. Hospices have been forced to close because of their opposition to MAID, such as the Delta Hospice in British Columbia, pictured there on the right, and on the left, sorry. And they're also religiously affiliated providers who have maintained their opposition to MAID have been widely criticised for forcing frail and vulnerable patients to transfer to other facilities to be assessed for medical assistance in dying. So I would actually argue that institutional conscientious objection, so healthcare institutions opting out of the provision of a medical procedure or service on the basis of their mission and values, I think that's a far less secure liberty than the right to kind of conscientious objection by individual healthcare practitioners. I think there seems to be just less public sympathy generally for big bad institutions, so to speak, than kind of the sort of more vulnerable individual practitioner when it comes to this particular issue of conscientious objection. Like many bioethicists say, like the whole idea of institutional conscientious objection is a fiction. Like institutions don't have consciences, and we shouldn't treat them similar to individual practitioners in this case. So let's just review briefly the case against conscientious objection. Why are conscience rights under pressure in medicine? So one might speculate that we're witnessing or have witnessed in the case of some of these more controversial issues a common pattern in social change whereby something controversial goes from being illegal and anathema to being exceptional and legal to being a legal right, and then that legal right must be respected by all members of society. There's a kind of this sort of steady sort of shift that often occurs in society with respect to controversial medical procedures and other things as well. Certainly this is part of the political backdrop, I would say, to the pressure that conscientious objectors have faced in recent years over the provision of medical assistance in dying, just to use one example, and that's in the case in Australia, where euthanasia was basically not only illegal, but more or less there was majority social opposition to it up until about 7 years ago, and now it is legal in every Australian state and soon to be every Australian territory as well. And the right to institutional conscientious objection has come under significant scrutiny. So I think there's just sort of a shifting of the needle that occurs in these cases, and that's partly why conscientious objection comes under pressure. So critics say that conscientious objection, it undermines access to healthcare services. The patients may not be able to access reproductive healthcare, end-of-life care, or any other service that may be the matter, sort of form the matter of conscientious objection in a timely or convenient manner. So medicine, however, should seek to satisfy patient preferences and facilitate a patient's realisation of their vision of the good life, like be argued. And the good of the patient just is the fulfilment of the patient's considered preferences. So beneficence collapses into autonomy on some accounts of the principles of biomedical ethics. Conscientious objection, if that's true, even if the doctor says they're trying to act in what they believe to be the patient's best interest, is an illicit constraint on patient autonomy as it kind of imposes values on the patient. So perhaps these considerations, as I just alluded to, provide context for the claim of an imposition of values in the context of conscientious objection. It's not uncommon to hear that claim made, and the exact meaning of the statement is not entirely clear a lot of the time, but perhaps the worry is that dissenting views may lead to limits on the choices available to citizens of liberal democracies generally, and in this case in medicine and healthcare, that it may restrict treatment options to patients. Alternatively, perhaps the concern is that doctors are going to express their views in a judgmental manner, or that the very act of conscientious objection constitutes a form of moral rebuke to patients. In kind of the more extreme cases, there are some bioethicists, there are admittedly some sort of fairly edgy characters in the world of bioethics. And the more provocative, controversial commentators argue that, say, for example, conscientious objection should just be banned, should be not allowed in medicine, and that we shouldn't admit conscientious objectors to the medical profession. So dissenting physicians should be grandfathered out, and medical schools ought to select students based on their willingness to provide these services in question. I'm not trying to say that everyone in this debate who has a different view to me is a bad faith ideological actor, right? I'm not trying to make that claim. I mean, some members of the medical profession sincerely believe that doctors should be prepared to do whatever the professional role requires, and that may be glamorous and edifying in some cases, and you may receive social credit for it, or it may be unsettling and morally distressing. But a good professional should be willing to get their hands dirty and set their own moral scruples to one side. Okay. So there's a lot that could be said in response to these criticisms. Critics of conscientious objection typically rely, I would suggest, on a cartoonish account of conscience. And let's face it, they exhibit a flagrant bias against religious perspectives in medicine. That's just my personal assessment of the literature. Some of the literature implies that conscientious objectors are dogmatists or fundamentalists who seek to morally chastise their patients. I would suggest that the reality is far from this, that in fact, your typical doctor who's a conscientious objector, they don't want to bring down the establishment. They're concerned, they're worried about their own professional future because they hold these dissenting views, and they're worried about what their actions, what consequences their actions will have for their career. However, they don't believe that they can provide a service that they've been asked to provide. And typically they're looking for a way forward that will cause the least possible disruption. And often that's the case of the institution as well, and mediation can often resolve the tension that exists. But just to get us started in terms of kind of this response, I would like, as a matter of principle, to present a slightly more robust account of the goals of medicine and the place of disagreement in the medical profession, which I hope will go some way to showing why we ought to permit physician discretion with respect to controversial medical procedures. The case for conscientious objection is largely built on the notion that the satisfaction of patient preferences are the proper goal of medicine. But it's only a half-truth. It's only a half-truth to say that medicine is about the satisfaction of patient preferences and respect for patient rights, as if medicine were like ancillary to some utilitarian social agenda, like where we're trying to maximize the satisfaction of preferences, or sort of some liberal conception of medicine, which, according to which medicine is about like augmenting people's ability to realise their conception of the good. Yes, informed consent is an important legal constraint on medical practice. I'm not a paternalist, and yes, doctors should accommodate where appropriate for the varied goals of care that a patient might have. But medicine is principally concerned with the realisation of human goods, and in particular the good of health and the relief of suffering. This view is as old as the Hippocratic Oath, exhibited on the far side of the screen. We cannot understand medicine without implicitly accepting something like this view. Doctors are in the business of saving lives, treating illness and injury, and relieving suffering. And there are exceptions to this, such as cosmetic surgery, but these are exceptions that prove the rule. Like if you're going to use cosmetic surgery as your standard for how we should think about medicine, I think you need to kind of rethink your approach, your methodology. If we literally believe that medicine had no therapeutic orientation, it would be difficult to say anything against consensual but manifestly inappropriate medical care. So referring a patient for unnecessary testing, the prescription of toxic or addictive drugs, the performance of unnecessary surgeries, and so on. Medical ethics, then, is not just about patient preferences, it's about human goods as well. Doctors often disagree, though, about what is good for their patients. We might be tempted to think that clinical disagreements are purely technical matters. They're disagreements about which interventions have the strongest evidence base or how to interpret relevant facts. This would be a mistake. No medical act is value neutral. There will always be a moral decision to the decisions that clinicians make, and there will always be a moral dimension to clinical disagreement. A thoracic surgeon, for example, may be consulted about whether to operate on a patient with an aortic aneurysm. The surgeon may conclude that it would be wrong to carry out the operation as the patient is likely to die more quickly as a result of the surgery. But another surgeon may disagree. They might believe that undertaking the operation is in the patient's best interest, as is the last chance of survival. And basic bioethical principles of beneficence and non-maleficence come into play and can be interpreted and applied differently in this case. This is a moral disagreement as well as a technical disagreement in this case. We should, as a rule, respect the doctor's judgment about what's good for their patient. In fact, we ordinarily do this. So what's different about conscientious objection? As I mentioned in my introduction, this particular topic, conscientious objection, has been reified in public debate in a manner that ignores its existence along a spectrum of legitimate disagreement in clinical medicine. And perhaps you'd like to resist this. Perhaps you'd like to say, no, Dr. Symons, to conflate conscientious objection with less morally charged disagreements about appropriate medical treatment is misleading. And if so, you may be tracking the intuition that, say, reproductive health care, end-of-life care, are in fact atypical medical procedures, or may involve atypical medical procedures that fall outside the traditional ambit of medicine. I think there's potentially something to this view, and what usually makes these procedures clinically indicated is a patient's preferences, or at best psychological or social well-being, rather than some diagnostic indicator of physical exam. That's worth considering. But that actually strengthens the case that I'm trying to make here. It's hard to see how the preference-driven medical interventions under discussion can be said to fall within the purview of moral obligation and basic medical care that medical practitioners must provide. If indeed there is something exceptional about certain aspects of reproductive health care or end-of-life care, then this is all the more reason why we should respect the right of physicians to conscientiously object. Appeals to conscience and moral distress. Sorry, the Simpsons reference is distracting. But perhaps we need to take a step back here and consider what exactly is meant by an appeal to conscience. There are, after all, different ways we can say an action is wrong. So we can say that an action is wrong because of its intrinsic character. It's just wrong always and everywhere, like murder or torture. We can say that it's wrong because of its consequences. So I shouldn't go dumping waste illegally in the city, chemical waste, which could potentially be of harm to people. It could be wrong because of the intention of the agents. I could give my professor praise for a fantastic lecture, so that essentially I get a better mark on my final essay, and so on. An appeal to conscience is a particular way of describing the wrongness of an action. It's not just a statement about the intrinsic character of a moral action. I think it also highlights the consequences of commission of that action by an agent. So for the agent themselves, there's a kind of self-reference involved in appeals to conscience. So this is a comment by James Childress, who actually is the kind of Childress of Beecham and Childress fame. And he says of appeals to conscience, when a person appeals to his conscience, he makes a hypothetical and prospective claim. He claims that if he were to commit the act in question, he would violate his conscience. This violation would result not only in such unpleasant feelings as guilt or shame, but also in a fundamental loss of integrity, wholeness, and harmony in the self. Appeals to conscience are statements about the consequences for personal integrity and moral character if an agent engages in an action they deem to be wrong. Conscience presents a picture of moral action as it relates to the self, and it highlights for an agent the consequences of wrong action for themselves. Alternatively, it leads us to make amends where we have wronged others. It's appropriate here to bring in a related concept in the healthcare ethics literature, namely moral distress. So we have an expert on the topic of moral distress here in the audience, Kate Jackson-Meyer, and I've been very grateful to work with Kate and others exploring some of the complexities surrounding defining moral distress and understanding how it affects healthcare practitioners. Definitions of moral distress typically focus on a conflict between a healthcare professional's deep moral convictions and the values that the individual is obliged to comply with in an institutional and social matrix. So consider, for example, Jackson, Meyer, Symons, and Duffy's definition, shameless self-promotion, of moral distress as healthcare professionals' perceived incapacity to fulfill their perceived personal or professional obligations. The term was coined by a philosophy professor, Andrew Jamerton, in a 1984 book, Nursing Practice, The Ethical Issues. Jamerton described moral distress as the experience of knowing the right thing to do while being in a situation where it's nearly impossible to do it. He was responding to healthcare practitioner stories related during classroom discussions of a range of bioethical dilemmas, such as appropriate care for dying patients, limits to life support, and communication and decision-making with patients and families. And by way of context, moral distress is a significant problem in healthcare today. Like, there's a lot of people talking about this. An editorial in the British Medical Journal, for example, recently noted that the slow tightening of the garret of underfunding has created ideal conditions for moral distress, sapping the joy from the doctor-patient relationship, depleting the rewards of clinical medicine, and swapping pleasure for grinding distress. The situation's only been made worse by the COVID-19 pandemic. So I would like to make the somewhat audacious suggestion that recent discussion of moral distress is in fact a conscience-driven discourse. The concept of distress and moral distress, the notion of distress as it forms part of this broader concept of moral distress is poorly defined, but I want to suggest it actually relates to disturbance of conscience. And the conscience, according to Aquinas, for example, is a capacity for judgment, which allows us to apply general moral principles to particular situations. Other philosophers have discussed the role of conscience in ensuring that practical actions reflect our deepest commitments, and in particular our understanding of right and wrong. So the distress experienced by moral agents when their personal beliefs and moral judgments come into conflict with what is demanded of them professionally is plausibly a product of a frustrated conscience. It is the effective state that one experiences when conscience makes one aware of moral conflict between values and professional obligations that constitutes the distress of moral distress. Now, this is just an idea, right? Like I haven't written on this, but I would like to float in the concept of this discussion, because I would actually argue that conscientious objection is a subvariant of moral distress. Some authors have tried to deny that this is the case. Consider, for example, the quotes up here on the slide. However, it's hard to see how this is anything but arbitrary. Like, for one, a doctor could believe that, in this case, sex reassignment surgery or abortion, as mentioned by these authors, conflicts with their professional obligations. So it's not necessarily the case that there's sort of something uniquely personal about the beliefs people can have about these procedures as opposed to other procedures. And related to this, the whole distinction between personal and professional moral convictions is somewhat artificial. It's one and the same faculty or capacity of moral reason that we use to determine both our personal and professional moral obligations. So there's at least some evidence to suggest that practitioners with a conscientious objection experience moral distress. A 2006 paper, I think it was, by Deborah Hanna, who's a researcher and registered nurse, actually wrote about the visceral pain and cognitive dissonance experiences by nurses who participated in elective abortions against their, in a sense, like against their deeper convictions. And I mean, this is one quote here from one of the nurses. I think the initial distress was that I was doing the wrong thing, that ending a life was doing the wrong thing, and that was the most gut-wrenching thing for me. So this sounds to me like a quintessential instance of moral distress triggered by an action that violates one's conscience. Just to briefly turn to conscience and professional virtue, because I mean, we can talk about the distress that practitioners experience, but the other side of the coin, I think, is the cultivation of virtue, like excellence in medicine. What link might conscience have to that? Well, building on these insights, I'd like to move to this topic of the restrictions of conscience in medicine and the effects that has on the cultivation of intellectual and moral virtue. In my book, I argue that there's actually a feedback loop between the way we act and our character and our deep self. So conscience, conceived of as a capacity for moral judgment, exists on the interface between the acting self and the deep self. It ensures that our moral and other commitments are reflected in our actions and also plays an important role in the constitution of self and identity. I think this is an important point, that like something like conscience, a capacity for moral judgment, actually potentially also has a role to play in sustaining a moral identity, because it discerns whether we've acted in accord with our deepest commitments, whether we're actually living up to who we think we are, and to what extent our actions actually reflect our deepest self-conception. Note that conscience is crucial to childhood and adolescent moral development. So the psychological literature on conscience is not super well developed, or if you were like psychologists, I think they don't necessarily think that conscience is the best way to conceptualize a whole lot of psychological phenomena. However, it is referred to in the context of childhood and adolescent moral development, firstly, and secondly, the literature on psychopathy actually is the kind of second area where there's a lot of discussion of conscience, because psychopathy is often defined as a deficit or absence of conscience. So psychologists define conscience in terms of basic pro-social virtues and capacities that children acquire at a young age and that help one to become a well-adjusted member of the community. A deficit of conscience, in contrast, manifests in narcissism, muted moral emotions, and is actually linked, as we mentioned, to the development of psychopathy and sociopathy. I would suggest you can actually apply something like this framework to the context of medical practice. Conscience operates on the interface, as I suggest in the second diagram here, of a physician's character and their practice of medicine. It ensures actually that physicians are socialised in a way that gives them an opportunity to, an appropriately deep understanding of their professional role. I think conscience performs an important role in, like, actually, if you're a clinician, actually discerning, okay, what is it I'm trying to do here? What is the identity of the clinician? What are the fundamental moral commitments that ought to underpin my professional practice? And it's only through exercising conscience that we can constitute moral and technical rationality in a way that fully comprehends the ideals that characterise excellence in medicine. In contrast, my concern is that if we basically don't give appropriate attention to conscience in medicine, we may fuel this pattern of regimentation and brutalisation of doctors that leads to what's sometimes described as moral segmentation. You may be wondering what that means. Well, it basically means doctors who've become numb to moral considerations as a result of just being traumatised in their junior clinical training. So I think actually there's a risk that you might fuel that moral segmentation and the depersonalisation of medical practice. essentially, I think you kind of risk cultivating the risk stifling the cultivation of virtue and professional identity. And so you've got a lot of like critics of conscientious objection, proponents of conscientious objection, conscious rights, who say that, I mean, we're basically going to create a generation of medical functionaries, robots or ATM machines who lack the intellectual and moral constitution to provide humane care if we basically try and take the idea of like personal moral engagement with your professional work out of the picture. Now, I must admit, like I've talked with the sort of a lot of these kind of the usual suspects who write on these topics. I've talked with a lot of them, and they say like I'm not like against conscience in medicine. I'm just against conscientious objection. But I don't think that like kind of really flies in a consistent way. We can talk about it in question time. But anyway, I mean, look, there's a lot of people who say that like you should leave your personal values out of your professional life. There are a lot of people who think that just makes a lot of sense. It's kind of an intuitive guideline for how to conduct yourself in professional life. But I actually think you undercut the work of conscience in that case, as conscience seeks to attain a unity between an agent's deep self and their actions, as I mentioned, and this personal, professional, or public-private divide that characterises life in a liberal society could actually, ipso facto, have an inimical effect on the moral character and moral identity of everyone, and in this case, physicians. Something like this observation is captured in that quote that I'm sure you've probably read about 5 times now. Any blank expectation that clinicians leave personal values out of their professional work I actually think it's psychologically unrealistic and morally damaging. And granted, professional detachment is an important principle as well. I'm not saying that we should make no distinction between professional and personal identities, but I think there's all the more reason to have a robust conversation about how professionals can achieve consonance and harmony between their personal, moral, cultural commitments on the one hand and the expectations of their professional role on the other. It's kind of a bad situation, I think, just represented. Thank you. So some proposals, just to close us off here. What is a positive upshot of this discussion of conscientious objection in healthcare? I'm just giving an eye on the time here. I think a series of pseudo-compromises have been proposed in the literature that belie a sense of due measure in handling moral conflict in professional life. So some commentators, aside from the sort of partial ban proposal, others have advocated for conscience tribunals, where essentially, if you're a doctor who has a moral objection to something, you need to like front up to a tribunal and justify your actions. But I mean, that just reminds me of the Vietnam War, like where conscientious objectors had to front up to these tribunals, and essentially like it's kind of guilty until proven innocent. It's like you're doing the wrong thing. Like to convince me otherwise, I think in those contexts, like that's my concern with this idea of like tribunals, which is the name, worries me a little bit. There are some people who say we should have referral requirements for conscientious objectors so that they can refer patients to like other practitioners who provide the service that they don't want to provide. I think that's a complex one. I think referrals are actually do constitute a form of moral complicity. We can talk about that in question time, but that's where I fall on that debate, so I'm not sure it's an adequate solution. I would actually argue for stronger and clearer legal protection for conscientious objectors. I mean, federal law provides some protection, but further clarity is needed. And as we can see, it's being tested, these principles are being tested by the agencies, like particularly when the agencies are kind of not particularly sympathetic to kind of freedom of conscience understood in kind of like a conservative moral tradition, legal tradition. So here as I mentioned, in the US, much of the burden rests with Health and Human Services, and many have argued that they're not necessarily doing the best job. But there are nevertheless also other things that should be done. I think there should be appropriate monitoring of medical schools in the way that they select medical students for admission to medical programs. I do think we need to have genuine diversity in medical schools, and there's a lot of discussion about how we interpret, how we understand the notion of diversity today. But I think, my view is that we need to have diversity of thought and opinion, and genuine diversity in that case. So we shouldn't discriminate against doctors who are potential doctors or medical students who are pro-life, who could potentially otherwise be negatively discriminated against in their applications. Some bioethicists, after all, have explicitly advocated this proposal. Like, there are people in the literature who say, like, medical schools just should not admit pro-life medical students, period. And I think that's insane, for various reasons. Not the least of which is that there are a lot of patients out there who would like a pro-life gynecologist when they're kind of going through pregnancy. So it's actually kind of an autonomy-based argument for having these sorts of practitioners in the healthcare profession, the medical profession. So in the end, a lot of negotiation and conflict related to conscientious objection occurs in the workplace. I think you do need effective mediation processes. That's just a sort of very basic way to de-escalate sometimes the tension that can be created. So a brief addendum before we finish. I'm conscious I've talked for a while, but there's this topic of the conscientious provision of care that's come up in the literature recently, and even in like newspaper opinion pieces and so forth, that essentially, following the Dobbs v. Jackson Supreme Court decision, commentators have encouraged mass civil disobedience by the medical profession and professional support for doctors who break laws banning abortion. I would like to limit myself to two brief observations. First, I think the situation is somewhat asymmetrical to what we've just been talking about. I pointed out earlier that conscientious objection in medicine is, at least until recently, has been permitted by law and sanctioned by relevant professional associations. So conscientious objectors are not breaking the law. I think breaking the law is a bit of a separate kettle of a different kettle of fish, and something that requires distinct analysis. So I mean, encouraging mass civil disobedience is a big deal. And I would just be concerned about professional associations encouraging physicians to break the law. That's a fairly big step, and something that carries with it, I think, a lot of implications for the way we think about the roles of professional associations and their relationship to the state. I'm not saying that we should always follow manifestly unjust laws, that there might not be cases where physicians should break laws, but I'm not sure this is one of them. I mean, regardless of what you think about abortion, I'm not sure that this is necessarily one of them. In conclusion, conscience rights in professional and public life have been subject to extensive criticism in recent years. It's one thing to say that everyone is entitled to their opinion. It's another thing to actually allow the full expression of dissenting moral and religious worldviews. And lawmakers and judges are increasingly hostile to religious or ethical worldviews that could lead someone feeling uncomfortable or inconvenienced to patients. So, I've argued that conscience rights should, as a rule, be respected. I've also argued that this is integral to the cultivation of virtue and avoiding moral distress, moral injury, and so forth. Essentially, I think that excellence in medicine presupposes agency, and agency presupposes the freedom to act in accord with one's conscientious judgments. Thank you.
Thank you to Xavier. In response, Marcus Corbin is a philosopher on the neurology faculty at Brigham and Women's Hospital, Harvard Medical School, where he co-directs the Human Network Initiative and is a senior fellow at the think tank Capita. His academic work examines the connections between modes of intersubjectivity, cognition, and human flourishing, and he is writing a book on belonging and world making for Yale University Press. Ian serves on the ethics committee at Brigham and Women's, and he helps to direct the Trust and Belonging Initiative at Harvard's Human Flourishing program. He studied politics, religion, and philosophy at Gordon College, Oxford University, Yale University, and Boston College. He has taught at a number of colleges and universities in the Boston area, and has published widely in venues such as the Washington Post, the New York Times, Newsweek, The Point, and Plough. In a former life, he founded and ran a contemporary art gallery in Boston's South End. Please welcome Ian.
Hey everybody. So this may be the worst rebuttal you've ever heard. I find myself in broad agreement, I think, with Dr. Symons' argument, but I want to sort of pull on one of the threads that he sort of lays out and see if we can come to understand a little more about why it may be that this is such a hot button issue right now, why conscientious objection should be the subject of so much vociferous disagreement. So it seems to me, and maybe we'll disagree about this, that issues like euthanasia and abortion are ones that reasonable people can have principled disagreement about. I think, though, the idea that a physician is sort of bound by some deep obligation to perform every kind of sort of medical procedure, right, has no licit right or ability to kind of step back from some, is sort of puzzling to me, right? You could imagine a sort of firm of tax attorneys where one of the attorneys has a deep objection to gambling and so doesn't want to sort of handle the taxes of any casinos. You could just imagine a whole plethora of situations where you could say, look, I'm committed to this operation, I'm committed to the work we do together. Here's one small aspect of our work that I can't in good conscience do. And okay, that could be annoying for that person's colleagues, it could be difficult to handle, but it's hard to see why this could be wouldn't necessarily be a fundamental abnegation of their duty. Now, of course, we don't have to play stupid. Obviously, things like abortion and euthanasia are some of the central, sort of proxy wars that we fight in the larger culture war that's going on, and that's not a war that's given to a whole lot of subtlety or nuance. Like, you're sort of, in a lot of cases, you're either on the right side of the issue or the wrong side, and maybe you're a truly horrible person if you're on the wrong side. So that, I think, probably plays in here. But I want to suggest that the situation that Dr. Symons describes in the conversation around conscientious objection reminds me a lot of some other kind of deeper dynamics that I've seen working in a hospital system, and that I've just seen looking at institutions around America, things like universities and corporations and indeed hospitals. Okay, so as a starting example, I have from time to time had occasion to sit in on some ethics meetings at a hospital. There was one particular meeting, maybe a year ago now, where one of the physicians who was part of this group remarked in passing that the job of a physician is to advise what would be in the best interest of her patients. It seems innocuous to me. It didn't ring any alarm bells. But general counsel stepped in and said, no, that is not what physicians do. The job of a physician is to advise as to what might be medically beneficial. Right? We do not deal in matters of what is best for a human person. Right? That could expose us to all sorts of risk of litigation. That could put us in a position of sort of exercising undue oppressive authority over the people in our care. So this sort of, I found this slightly bewildering. We came back and we spoke again a little while later, and I brought it up. And again, I'm the lone philosopher there. It's mostly physicians. And I said, I brought up this comment, and I said, what an odd way to be in a room, right? Like, to be in a room advising someone about really intimate, really weighty matters, but to have to leave aside the part of yourself, right, where you have some personal understanding of what a good life looks like. You have some understanding of what flourishing looks like. That must be really alienating to work in that environment. And all of the physicians nodded their heads vociferously, right? Like, they are being asked, they feel, to operate in a way, and not just around these super hot button issues like this, but sort of across their working lives. They're often being asked to sort of leave their personal selves. That's my 4-year-old Eddie. Leave their personal selves, leave their sort of deeper convictions, their understanding of what is ultimately true and good at home, and sort of operate within the constraints of the system. Right? So to act, in Dr. Symons' phrase, as functionaries. I think far too often what you see across all these different kinds of institutions is a kind of depersoning of our institutions, right? This idea that, like, you kind of leave yourself at home and you become a sort of good servant of whatever the system is. Unfortunately, in a lot of the cases that I observed, from universities to corporations to hospitals, there isn't necessarily anyone sort of steering the ship, right? Instead, a lot of times what you see is a sort of system that's been put in place. And if I could generalize a little bit, the general shape of those systems is that there's capital that's been invested, and it wants to grow, right? Maybe that's because there are shareholders in some distant land who each own a little piece of it, they're going to buy and sell based on how it does this quarter, right? Or because there's a sort of owner there who says, I've put in a great deal of money and I expect to have growing revenues year over year. So you have that, and then on the other side you have consumer preference, which is basically sovereign here, right? Because that's how capital grows, is by sort of making consumers happy, making them want to spend more money and purchase more goods or services. So I think it's not an accident that in the 70s and 80s, as the principle of autonomy was sort of coming to the fore in medical ethics, that you see a sort of notable rise in direct-to-consumer pharmaceutical marketing. Right? So like this is a period in the history of bioethics where a lot of people started to think that, okay, we shouldn't have physicians sort of exercising such a godlike role in the doctor-patient relationship. We should have them back off. We should really make autonomy of patients the sort of central plank of what we're doing here. Well then, okay, the pharmaceutical corporations were very pleased about this, and so now they sort of invest, millions and millions of dollars to provide the guidance for the patients that, doctors are sort of encouraged to step back from a little bit. It's of a piece, I think, this movement towards a kind of two-part engine between, capital that wants to grow and consumers, whose wishes we wish to meet. A sort of bigger change that we see in the United States around the same time. So I think it's 1970, Milton Friedman publishes in the New York Times Magazine an article that argues that the businessmen and women have no business trying to think about what a good society looks like. They have no business trying to orient their activities, the activities of their employees, towards some vision of having a good life, having a good society, right? Having a good community. Instead, their job is to increase the sort of holdings of the shareholders as much as possible. And then, if they have, some cute little convictions about how the world ought to be, they can invest their own private monies into those sort of causes. So, okay, it sounds like a fairly neat system, right? Like we compartmentalize, we put aside these sort of deep, difficult philosophical questions. We let our institutions run like machines, and then you be a nice person on your own time. So I don't think it works, and I think it will become increasingly impossible to maintain as time goes on, right? So we hear constantly in the medical field about physician burnout, right? We hear, employers in the broader sort of commercial world complaining about quiet quitting, right? About the fact that their employees don't seem that bought in, right? Don't seem that motivated, don't seem that loyal to the operation. I don't see how you could be that loyal to these sort of operations, right? Like, I don't see how you could feel excellent about your work as a sort of carer for bodies if you really have to operate in this sort of amputated, half there sort of mode. So I think it's a big problem we're going to have to deal with, right? I think there's a lot of sort of looking around and wondering how we're going to sort of get nurses and doctors to kind of stay here and to not abandon ship, not be entirely miserable in their work. I think this is a pretty core thing. So in that context, again, abortion and euthanasia, big, difficult, deep questions, right? But I think the question of whether or not I can exercise some sort of moral agency in my professional life is a really deep and broad one, and it's one we're going to have to find ways to answer moving forward, and I think different ways than we have been. Or really, frankly, a lot of our institutions are just going to stop functioning. And I'll leave it there.